Law Talk with Nick Maruchak, thanks to MKI Legal, your trusted employment and family lawyers.
Good advice. The law wins 9 times or 10 times out of 10, doesn't it, Nick?
Yeah, the law wins a lot, unfortunately. So we've got to fight, but you got to have the good fight.
The law wins a lot. I like it. If you'd like to speak to Nick Maruchak, you can 1338 882. Listening to the Breakfast Boys this morning talking about smacking kids might be against the law in Queensland. What's your understanding of the current frameworks in WA?
So in WA, you are allowed to smack your child. There's actually a specific legislation. It's 257 of the Criminal Code. It's a complete defence. It says it's lawful for a parent or a person in place of a parent or a schoolmaster to basically use reasonable force for the purpose of corrective action, right?
Right.
So it's got this old school word, schoolmaster, in there.
Yeah.
So it allows a parent or a schoolmaster or someone or a guardian to use reasonable force. And what does reasonable force means? It only takes you so far. So as soon as you start leaving marks, bruises, injury, or something beyond a short-term discomfort, that will cross the line. So if you hit your child in anger, that would cross the line. If you hit them in certain body parts, like on the head, the face, the neck and stuff like that, you use an implement like a wooden spoon, like I used to when I was a child, that would cross the line. And then, so in WA, then that would be an assault charge against the parent if they do that. The police obviously have discretion whether to prosecute or not. But I also say with the schoolmaster defence, there's a whole bunch of laws that say you can't hit your child if you're a teacher. You know, there's if you're in a professional capacity, you can't. Corporal punishment is actually illegal. But it's interesting how it still has that schoolmaster defence in the criminal code.
Yeah, thanks, Nick. Well done. What section of the criminal code was it?
It is
227.
257.
257. Thanks, Nick. Vicky's phoned in. Hi, Vicky.
Oh, too late. Oh, hello. Thanks for taking the call.
No worries.
I've got a query about a will. My father died 12 years ago. He left everything to his younger second wife, and we were told at the time that we would be looked after when she passed. They had just redone their wills. Now, the second wife died early on this year. Her son from a previous marriage is the executor. I haven't seen the will, and while I've been in touch with the son about, he told me there was nothing in the will left for my sister or myself, even though that was my father's wishes. And negotiations for some small amount from the estate have fallen through, and he does not want me to contact him again. The house where they both lived is on the market at the moment. I haven't got a copy of the will, and as far as I can see from the portal on the Supreme Court site, no probate has been put through yet. I'm just wondering if you think we have a chance to contest the will, or have we know what I should do, basically.
Yeah, so Vicky, very complicated situation.
Yes.
The traditional sense of challenging a will involves you have to be in a certain class of people. You don't meet that class because you have to be a child or a grandchild or a parent. You have to have a close family relationship. So you can't challenge the will through the traditional mechanism. It's called a family provision claim because this is your stepmom and stepchildren have limited rights, especially if they're not financially dependent. But what you do have is if there's been a promise made to you. So if your stepmom made a promise to you that during your lifetime, during her lifetime, that she would leave you something, and you relied on that promise, especially if when your father passed away, you could have challenged your father's will, right? And you chose not to because of maybe the representation being made that you'd be looked after in her will. So that's something called promissory estoppel, right? So you might be able to make a claim against your mother-in-law's estate, stepmother's estate, for the loss you've suffered as a result of relying on that promise. So there is complexity involved in that, but you potentially may be able to come up with a legal argument. You sue the estate, the executors then have to consider the claim and make a decision on whether they settle or not. I would recommend you go speak to a lawyer about this because these things are complicated. And one lawyer I would recommend is Elise Croft from Croftbridge.
Sorry? Leave Croft?
Elise Croft from Croftbridge. So Elise does a lot of this work, this contested stuff, and I would sit down with her or someone who knows deceased estates to find out what you can do. But the crucial part here is that there was some sort of representation made to you, especially by the mother, by the stepmother, that you would get something, and you relied on that to your detriment, right? If you can establish those two things, you potentially can get up a claim, and then it comes down to, well, what is your losses? What is a fair amount to give to you? So,
Vicki, I'll put you back to Anne if that's okay, and Anne will pass on Elise Croft's number for you. We'll get you sorted and let us know how you go, Vicki. That, as I say, considerable complexity in all of that, and particularly the time involved. 19 minutes to 11 o'clock. Hello, Troy.
How you going, mate?
Good, Troy.
So I've basically bought a car because I've got a daughter on the way, our first child. We've only done 1,087 kilometres in it. Basically, we took it in there to get it looked at, never got looked at by the person that we bought it from. Picked it up. I said I was going to go take it for an inspection. He's had a big kerfuffle over it and said, "Oh, you're wasting your time, this mechanic's crap, this, that." And then I've taken it in yesterday, and I've received a checklist with 16 problems with it. So first of all, there's a couple major ones like turbo seal leaking, covered in oil. Hose pipes have been glued on. Some hose pipes have been melted with plastic to hold them on. Engine cover brackets are broken. Glow plugs need replacing. Surges on, cold start. Oil level overfilled, which isn't a major thing. Mm-hmm. Major oil leaks from engine, transmission, transfer case and differential. Front CV boots throwing grease. Front lower control arm brushes split and perished. Rear diff.
So where's it at, mate? You've got the 16 problems, including the major turbo problems. Where's it at? What's happened?
I've currently got it at home.
Right. So you've done 1,000 Ks in it. You got it at home. And what's your question to Nick?
So basically, where would I proceed with this? As it comes with 3 months warranty, but the bloke doesn't want to hand back the money. And at this rate, he seems like he doesn't want to fix it either.
So you want to take it back to the purchaser, right? Or the bloke where you purchased it from?
Yeah. So It is second-hand, I understand that, but he's offered 3 months warranty when I bought it.
Okay. So you bought it from a dealer,
$5,000 car. Yep.
So you bought it from a dealer. That's the important part, Troy, right? And just confirming it was a dealer, it wasn't a private seller?
No, it was a dealership, yes.
Okay. So the 3-month warranty that he offered isn't actually, he didn't do it out of the kindness of his heart. He had to offer that to you. It comes down to every motor vehicle that's sold through a dealer. If it's less than 12 years old, more than $4,000 purchase price. If it's got less than 180 Ks on the clock, you do get a statutory warranty. So it's less than 10 years old, you get this 3 months or 5,000 Ks. You're within the warranty, right? So he has to provide that to you. The next really important thing that you have is the Australian consumer law. I talk about this a lot. The Australian consumer law basically puts in terms into every consumer transaction that can't be contracted out of. And here the main term is that you purchase this vehicle, it has to be of acceptable quality, right? So what that means is if the vehicle is not of acceptable quality, then there are two things. If there's a minor fault in it, then the dealer can choose whether to refund you or repair it. If there's a major fault, then you have the right to either repair or replace it or a refund. Here, I think you should go for the refund. The other thing is if there is several small faults all put together and had you known about that, you wouldn't have purchased it, that can actually classify as a major fault, right? Yeah, right. So I'm listening to you, and I don't know much about cars, but I can tell that there's a lot of small faults or potentially some even major faults there, right?
So just in terms of process, what would Troy do? Does he send an email to...
So you try and negotiate with him and say, look, you breached the Australian consumer law. I would like my vehicle back. There are major defects in it. I have the right to get my money back. So push for that, because I wouldn't trust this guy to repair the car. I'll get your money back. If he doesn't do that, then you would have to commence a claim in the Magistrates Court. Because your claim is less than $10,000, if you commence it in the Magistrates Court, you go through the process of proving your case to the judge. Win or lose, you don't have to pay his legal costs, so you're protected there. I think the case sounds really good, right? So it's a matter of, if he doesn't refund you the money, you'll have to go and sue and commence a Form 4 claim, and it's a minor case claim. Fill it in, get a process server to do it.
All right, and I know, Troy, with you, that time is important to you with the baby due. Troy, send him an email, hey, and get it right. Let us know how you go, Troy, because we do have the car company's name, don't we?
Yes. Yes, I'm pretty sure, don't you?
Yeah, we do. I've got the email here, yeah. So.
And one last thing, the dealers are governed by consumer protection, so you can make a complaint to consumer protection and see if they would prosecute or investigate him any further.
Seems reasonably straightforward, Troy, but let us know how you go, hey?
Not a problem. Great. Thank you guys very much.
Thanks, mate. Thanks for calling in. 133 882. We'll take a break. If you'd like to speak to Nick Maruchak, you can. Phone lines are open. Or you can text us as well, but obviously calling in is the way to go. 133 882 in case Nick has some supplementary questions for you. It's 14 minutes to 11 o'clock. Joe says via SMS, Simon, tell us who the car dealership is so no one has to go through these rip-off merchants. Joe, I'll keep my powder dry on that one, Joe. I appreciate your thoughts, mate, but we'll just keep our powder dry and give the dealership the opportunity to refund Troy. And if not, that doesn't happen and it gets ugly, you'll be the first to know, Troy. Thank you, mate. It's 10 minutes to 11. We're just getting one side of the story, obviously. G'day, John.
Yeah, g'day, mate. How are you?
Good. What's happened?
Last October, I flew from Amsterdam to Qatar and then Qatar to Perth. On both of those legs, I'd paid for a priority seating. From Qatar, I got the seat I paid for. From Qatar to Perth, I didn't get the seat I paid for $500 odd for the two seats. I said, I want the seat I paid for. The head steward said, well, we can't do that. Someone else is in those seats, and we'll give you a refund. When I got back to Perth, heard nothing. 2 months later, I contacted them. They said they would get onto it, and they never came back to me. 2 months later, I contacted them again, heard nothing, and they promised they would get back to me. They don't seem to really care, mate, and I'm $500 out of pocket.
Yeah. How long is that flight, mate?
12 and a half hours.
Ooh, okay. All right. What do you reckon, Nick?
Look, you've got to, they operate in Australia, right? So they're covered by the Australian consumer law. So it sounds like you're entitled to a partial refund of that. Which airline was it? Which airline was it?
John, what airline, mate?
Qatar.
Okay, all right. So there is this ombudsman that you can complain to that's called the Airline Consumer Advocate, but it only really applies to Qantas and Virgin, so it's limited. So here you would have to write to them and say, just use Australian consumer law. Say that you're entitled to a refund because they didn't deliver on the promise the representation they made to you. You won't get the refund for the whole flight. You'll get the refund for the upgrade. And so write them a letter, and if they don't refund it, then you can also do the same thing as the previous caller, go to the Magistrates Court. But you might want to even just fill out a Form 4 from the Magistrates Court website, fill it out, and then just send that to them and say, look, I'm going to file this if you don't do anything. So you got 6 years to commence that. So you're well within time. So that's what I would do. And then you can also try it Department of Consumer Protection, but that's often hit and miss as well. So you just want to force them with the law. And if you want to, you can go to the Magistrates Court, and then you should get a result if you go through that effort.
So, John, have you actually emailed them or just called them?
No, I've emailed them. I've got a response to say they've received a complaint, and then nothing happens.
Yeah,
I really feel that there should be some punitive damages levied against them. They just can't treat people like this.
I agree.
Yeah, so there is some provision in the Australian consumer law for a penalty, but most of the time you probably just get your refund, and that was it. So, but I would pursue it, and you've got a claim there. It's just a matter of jumping through the hurdles. Yeah,
John, let us know how you go. That's fairly straightforward as well, isn't it? Geez, that's frustrating. 7 minutes to 11 o'clock, a 12.5-hour flight too. It's not like it's not like it's just an overnight, a quick hop, step, and a jump flight. Good luck, John. Hi, Diana.
Hi. I wanted to ask about a car which is still in my son's name, but someone else is using, and he's going to want it back. Do I have a leg to stand on if I go to the police and ask for them to return it?
It's in your name, sorry?
It's in his name, my son's name.
So, yeah, your son should go to the police and ask it to return it. So your son should first contact the person and say, return my car. I need my car back. It's my vehicle. And if he doesn't return it, then that potentially might lead to, that might be a crime, right? So then he's using the vehicle without the owner's consent. So then I would go to the police. And if hopefully the police do help you and don't say it's a civil matter, because sometimes they do. If they turn you down and say it's a civil matter, then to get the car back, you actually have to go to the Magistrates Court and commence a claim to get return of the vehicle. So, so you would write to the driver and threaten them with that.
Is it an ex relationship or something, Diana? Why's the person got the car?
I don't know.
All right. Yeah. Well, your son has every right to ask for the car back upon his return. And what's your second question?
Thank you. Who does what when the person dies without a will?
So there is something, the law is the Administration Act. Go to Section 14. It's called, the legal definition is entitlements on intestacy. So this Section 14 of the Administration Act, you can also Google it as well, sets out if you die in certain circumstances, this is the automatic inheritance that everyone gets, right? So it goes through a bunch of factors, and it goes for all the way from husband and wife all the way down to, I think, cousins. And then if you don't have the family members on that list, then it goes to the government. So we do have a very detailed system of how inheritance work if you don't have a will. So it's important to get a will, so it actually goes to whoever you want it to go, not these default provisions.
Thanks, Diana. Hope that helped. Good luck with the car. G'day, Rob.
Hey, boys. Yeah, simple question, I hope. If a child is estranged from one parent and then changes their surname to their step-parent's name and they're excluded from a will, would that work against them if they attempted to challenge that will?
No, because what they look at is they look at the relationship. So to challenge the will, to commence the process, you have to put a birth certificate down, and as long as there's a birth certificate that says you are the biological child, you have the right to challenge it. When it comes to changing your name and stuff like that, that's a whole nother question on whether the person deserves to get something from the will. This area is quite complicated, but if you are estranged as a child, the court won't really put a lot of blame on you because you're a kid and you can't control it. But if you're estranged as an adult from your parent, then they will look at that relationship just to see on how it happened, and they'll weigh all the other beneficiaries' rights with your right. They'll look at how much is in the pie to divide. There's a whole bunch of complicated process. But the short answer to your question is no.
Thanks, Rob. Cheers, mate. Thank you. That's all we've had time for this week. Nick's gone really quickly. Thank you. We'll keep an eye on the Erin Patterson death cap mushroom case, which is incredibly interesting and sad and tragic all at once. But maybe we can have a chat about that next week, and a result, an outcome may be known, hey? Yep. Yeah, all right. Thanks, Nick.
Thank you,
right. Cheers, mate. Nick Maruchak from MKI Legal. We're lucky to have him. We'll take pause. When we come back after the news, Mick Collis, the beautiful mind of Mick Collis, will join us in the studio.